Imagine being dragged into a legal battle over a community you don't even belong to, all because one overly controlling neighbor, let's call her Karen, thinks she runs the entire town. That's exactly what happened to me. She tried to sue me for violating HOA rules, while I wasn't even part of her HOA. But what she didn't expect was that I'd fight back. And within minutes, I turned the tables, not only beating her lawsuit, but legally dissolving the very HOA she tried to weaponize against me. Let me walk you through the wildest 3 minutes of legal judo you've ever heard. Karen had always been the kind of neighbor who thrived on control. She wasn't just a homeowner. She had become the self-appointed guardian of the neighborhood's so-called values. While most people joined the HOA to maintain property standards and ensure community harmony, Karen joined it with a different mission: power. She relished enforcing rules, sending out warning letters, and patrolling the streets like a sheriff in a quiet suburban town. It wasn't unusual to hear stories of her measuring grass height with a ruler or citing neighbors for having the wrong color of blinds visible from the street. At first, I dismissed her antics as nothing more than someone with too much time on their hands. But soon, I realized she was capable of more than just passive-aggressive behavior. When I bought my property, I made a conscious choice to live just outside the HOA boundaries. I had heard stories about neighborhoods run like miniature dictatorships, and I wanted no part of it. My home, according to the plat maps and the legal description on my deed, was not subject to the HOA's jurisdiction. I liked my freedom, the ability to park my truck wherever I wanted, plant what I wanted in my yard, and not worry about getting a fine for leaving my trash cans out past noon on collection day. For a while, I enjoyed that independence without interference. Then Karen noticed me. It started with small things. She left a handwritten note on my mailbox saying my fence wasn't in compliance. I ignored it. Then she rang my doorbell one afternoon, clipboard in hand, and began lecturing me about how my mailbox post was 2 inches taller than the HOA allowed. I politely told her I wasn't in the HOA and closed the door. But Karen wasn't deterred by facts. She operated in a world where perception overruled reality. And in her eyes, I was a rogue resident defying her authority. The situation escalated quickly after that. She began photographing my property, documenting every minor detail she could use as evidence. I caught her pacing on the sidewalk outside my home with a measuring tape, taking down notes like a private investigator. One day, I came home to a certified letter waiting for me. I opened it, expecting perhaps another warning or citation, but what I found was far more serious. She had filed a lawsuit against me for noncompliance with HOA regulations. The document was filled with every document I uncovered, one thing became crystal clear. Karen was overstepping in a massive way. Not only did the HOA not have authority over my property, but its very legal foundation had serious issues. Yet Karen didn't back down. In fact, she became more aggressive. She began calling community meetings, stirring up other board members, and even tried to pressure my neighbors into signing a petition to have my property annexed into the HOA jurisdiction. It was almost laughable, but I knew this was more than a nuisance now. It was a battle for my rights. Karen had crossed a line, and she was dragging a legally shaky organization with her. While others might have caved or moved away, I decided I would meet her energy. If she wanted to play the legal game, I'd play it too. But I wouldn't just defend myself. I'd go on the offensive. And as I dug deeper, I realized the HOA wasn't just powerless over me. It was vulnerable. Its formation paperwork, filed decades ago, was incomplete. Several amendments were never registered with the county. The bylaws contradicted themselves, and it had failed to meet state compliance updates for years. It was a ticking legal time bomb that Karen never saw coming. The letter arrived on a Wednesday, tucked neatly into a certified mail envelope that I signed for without a second thought. At first, I assumed it was another one of Karen's exaggerated warnings. Maybe something about my exterior lights or my trash bin being visible from the curb. But as I tore open the envelope and scanned the first page, my heart slowed. It wasn't a warning. It was an official notice of a civil lawsuit, filed in the county court, with my full name as the defendant. The plaintiff, the homeowners association that Karen presided over. A lump formed in my throat as I flipped through the pages. Each line was more absurd than the last. I was being sued for allegedly violating HOA codes, rules I had never agreed to, for a neighborhood organization I wasn't even a member of. The lawsuit read like a parody of suburban micromanagement. It cited violations like improper lawn maintenance, unapproved exterior paint color, an unauthorized vehicle in my driveway, and something about non-conforming architectural fixtures. All of it was framed as though I had been warned multiple times and chosen to ignore the HOA's authority. But none of that was true. I hadn't received any official communication except for the hand-scrawled notes Karen left on my porch and the verbal warnings she delivered uninvited at my door. There were no registered letters, no emails, no citations. Just Karen's personal vendetta disguised as HOA enforcement. As I flipped to the signature page, I wasn't surprised to see Karen's name listed as the acting president of the HOA board. It was all starting to make sense. This wasn't a case of mistaken identity or a clerical error. It was personal. Karen had weaponized the HOA to make my life difficult because she couldn't stand the idea of someone living near her and not bowing to her rules. She was so obsessed with control that she would rather drag me through court than accept the fact that I didn't fall under her jurisdiction. What made the whole thing surreal was that I had done my research before buying the property. I specifically chose a home that was on the outskirts of the development, one that had been subdivided before the HOA was ever formally established. The property deed didn't mention any HOA requirements. The title documents were clean. I had even confirmed with my real estate agent and the county recorder's office that the lot was not included in the HOA's governance. So to be sued for violating something I legally had no connection to was not only frustrating, it felt like a violation of common sense. Still, a lawsuit is a lawsuit. Whether justified or not, I knew I had to respond. Ignoring it wasn't an option. Karen had filed the claim as if it were a legitimate enforcement action, and if I didn't challenge it, the court might assume she had the right to do so. So I did what anyone would do in my situation. I called a lawyer. The attorney I spoke with was just as confused as I was when he read the case. He said it looked like a textbook example of frivolous litigation and couldn't understand how it had even been filed without proof of HOA membership. But he also warned me that some HOAs operate under the assumption of implied authority and that, if left unchallenged, these assumptions can sometimes carry weight in court. That warning fueled my sense of urgency. I wasn't just going to defend myself, I was going to dismantle this nonsense. I gathered every document I had from the property purchase, printed out boundary maps, and dug through archived records online. I wanted to be absolutely sure there was no technical loophole Karen could exploit. The more I investigated, the clearer it became that my house was completely outside of the HOA's legal reach. There was no signed agreement, no easement, no clause hidden in fine print. I was a private homeowner living freely, and Karen had no right to claim otherwise. But she wasn't acting alone. Within days of receiving the lawsuit, I noticed changes in how my neighbors interacted with me. Some waved more cautiously, others avoided eye contact. It was clear that Karen had started spreading her version of events, casting me as the rogue resident refusing to play by the rules. She painted herself as the protector of neighborhood values, bravely standing up to the lone troublemaker. Her tactics weren't limited to the courtroom. She was trying to win a war of perception too. I refused to let her shape the narrative. I remained calm, didn't retaliate, and didn't feed into the drama. But behind the scenes, I was building my response point by point. I filed a formal answer to the lawsuit, denying every accusation. I attached copies of the deed, the title report, the zoning map, and a letter from the county confirming my exemption from the HOA. I even included a notarized affidavit from the title company who had handled the sale. I wanted there to be no ambiguity, no wiggle room, no possibility that Karen could twist the facts to fit her fantasy. When I first bought the property, I did everything by the book. I worked with a reputable real estate agent, thoroughly reviewed all disclosures, and spent hours going over the fine print in the title documents. My goal was simple: to find a home in a peaceful neighborhood that wasn't governed by an HOA. I had heard too many horror stories about homeowners associations turning into power-hungry regimes, and I wanted no part of that lifestyle. Freedom was important to me, The idea of having to ask for permission to plant a tree or repaint my fence didn't sit well, so I deliberately searched for homes outside any HOA boundaries. After weeks of searching, I found the perfect place. A quiet house on the edge of a suburban community, just a few lots removed from the HOA development zone. According to every legal document, including the property deed and the parcel map from the county recorder's office, this home was not under HOA jurisdiction. That was a major selling point, and it gave me confidence in my decision. So when the lawsuit arrived and Karen accused me of violating HOA rules, I was genuinely confused at first. Not surprised that she was upset, because she had already proven to be obsessed with enforcing her personal sense of order, but confused about how she could legally take it this far. I revisited all of my documents, combing through them line by line, double-checking everything. The property was indeed located outside of the boundaries listed in the HOA's charter. I even found an old survey map that clearly showed my lot was not one of the parcels initially included when the HOA was formed. My address was excluded from the list of covered properties in the HOA's original filing. That single fact rendered every accusation in the lawsuit baseless, but Karen either didn't know that or didn't care. Rather than reacting with frustration, I decided to stay focused and gather more evidence. I made an appointment with the County Land Records Office and requested certified copies of the subdivision plat maps. These were the official documents that showed how the land was divided and who had jurisdiction over each section. Sure enough, my lot was highlighted in a different color, indicating that it fell outside the scope of the HOA. I also requested a full copy of the HOA's governing documents, which listed every property included in the association. My lot number and street address were nowhere to be found in that list. That was my smoking gun. Clear, legal proof that I was not bound by any HOA rules or responsibilities. To be absolutely certain, I went even further. I contacted the title company that handled my property purchase and asked them to provide a written statement confirming there were no HOA obligations tied to my property. They responded promptly, stating that they had conducted a thorough title search at the time of sale and found no evidence of any encumbrances or agreements requiring HOA membership or compliance. This letter became another critical piece of my defense, and I added it to my growing collection of documentation. In my mind, the situation was resolved. I had proof beyond a shadow of a doubt that I was not in the HOA. Anyone looking at the facts would come to the same conclusion. But Karen didn't operate on facts. She operated on control. She wasn't interested in the truth. She was interested in asserting dominance over the neighborhood, and I had become the latest target in her crusade. She seemed to believe that by sheer force of will, she could include my property in the HOA and bring me under her authority. Maybe she assumed that most people wouldn't dig into the records or fight back, and that the threat of legal action alone would be enough to force compliance. Unfortunately for her, I wasn't wired that way. I wasn't going to roll over and let someone bully me into submission, especially not when the law was clearly on my side. With every document I collected and every fact I verified, my confidence grew. I knew that I had to respond to the lawsuit not just with a denial, but with overwhelming evidence that would leave no room for interpretation. I began organizing everything into a binder: maps, letters, records, legal descriptions, timelines, so that if the case ever made it in front of a judge, I could present a comprehensive, undeniable argument. Karen's entire claim rested on a fantasy, and I was preparing to confront it with unshakable reality. After confirming that I had no legal obligation to the HOA, I turned my attention to something even more significant: the HOA's own legal standing. I wanted to know how it was formed, how it operated, and whether its authority had ever been legitimately established. At first, this was just for my defense, something to reinforce my case and protect myself. But the more I learned, the more cracks I found in the foundation of the HOA itself. What began as research turned into a mission to uncover the truth about how this association had been functioning, and whether it had any legal legitimacy left at all. I started by requesting public records from the county clerk's office. These included the original articles of incorporation, any amendments filed over the years, annual meeting minutes, financial reports, and correspondence with the State Corporation Commission. To my surprise, many of the key documents were missing. There were gaps in the record where annual filings should have been. In some years, there were no meeting minutes, no election documentation, no updates to the board member list. It was as if the HOA had existed in name only for long stretches of time. That was a red flag. Even more alarming was the original filing of the HOA's charter. The document that legally created the HOA had some serious issues. First, the boundaries listed were vague, referencing lots and parcels without clarity or proper legal descriptions. Second, it appeared that the necessary consents from homeowners, the kind of approvals required to legally form an HOA, were never properly collected or notarized. There were signatures, yes, but many were illegible, and a number of them didn't even match the names on the original property titles from that period. It looked sloppy, unprofessional, and possibly fraudulent. This wasn't just a poorly run organization. It was potentially invalid from the very start. That discovery gave me leverage I hadn't expected to find. If the HOA was never properly formed, then it couldn't enforce anything. Not just against me, but against anyone. It meant Karen's authority, and the rules she was so obsessed with, were built on a foundation that might not hold up in court. I knew then that I needed to take this further, not just to protect myself, but to protect my neighbors, many of whom were living under the assumption that they were legally bound to rules that may never have been enforceable to begin with. I kept digging. I found inconsistencies in the HOA's bylaws. For instance, one section stated that annual elections for board members must be held with full membership quorum, but according to the few meeting notes I could find, no such quorum had been met in years. Another section outlined a requirement to publish financial statements to all members, yet there was no record of such distributions for over a decade. These were not small technicalities. These were major compliance failures that could expose the entire organization to dissolution under state law. To confirm my findings, I contacted a property law specialist who had experience with homeowners associations. I scheduled a consultation and brought all the documentation with me. Original filings, maps, inconsistent records, even screenshots of missing state filings from the government website. After reviewing everything, the lawyer confirmed what I suspected. The HOA had not only failed to meet legal requirements for years, but it was also vulnerable to being challenged in court or even administratively dissolved by the state. The organization, in legal terms, was a shell barely functioning, improperly maintained, and with no enforceable authority over non-consenting homeowners. This revelation changed everything. I realized I didn't just have to defend myself. I had the opportunity to put an end to the chaos Karen was causing once and for all. She had operated for too long on the assumption that no one would question her, that her threats would go unchallenged, and that her word would be enough to impose rules on everyone around her. But now I had the tools to challenge the very thing she clung to for power. It wasn't just about clearing my name anymore. It was about confronting the entire structure that allowed someone like Karen to bully others under the guise of authority. I knew the next step was to take what I had found and present it to the right authorities. Not just to defend myself in court, but to make sure the HOA was held accountable for its failures. The legal system had mechanisms for this. Complaints that could be filed with the State Corporation Commission, motions that could be submitted in court to challenge an entity's legitimacy, and administrative processes that could trigger a review of the HOA's status. Karen may have started this fight by coming after me, but now I was prepared to fight back with everything I had uncovered. After weeks of research, document gathering, and legal consultations, I was ready to make my move. It wasn't just about presenting my case in court anymore. It was about targeting the heart of the problem. I had everything I needed. Confirmation that my property was outside the HOA, proof the HOA had been operating without legal compliance, and an attorney's validation that the organization was vulnerable to legal challenge. But instead of waiting for the court date to arrive and letting Karen's lawsuit drag out, I decided to go directly to the source, the county recorder's office, where the HOA's original existence was filed and where its legal standing could be examined, questioned, and potentially dismantled. I scheduled an appointment with a clerk at the county office, bringing my stack of documents neatly organized and labeled. The appointment wasn't about confrontation, it was purely procedural. I explained that I had evidence suggesting the HOA in question was not properly formed and had failed to meet the requirements for maintaining its corporate status under state law. The clerk was professional and thorough, asking detailed questions and carefully examining the records I provided. I showed them the inconsistencies in the bylaws, the absence of proper filings, and the flawed boundary descriptions in the original charter. Everything I had uncovered was on the table, backed by paper trails and official statements. What surprised me was how familiar this kind of issue was to them. Apparently, it wasn't uncommon for HOAs to fall into administrative disrepair, especially when power-hungry individuals like Karen push things beyond the limits of legality. The clerk reviewed the documentation and confirmed that the HOA had indeed failed to submit required updates and filings for multiple years. Under state law, that failure opened the door for administrative dissolution, especially when combined with evidence of governance breakdowns and improper enforcement actions. The process wouldn't be instantaneous, but it was now officially in motion. A review would be launched, and the HOA standing would be challenged at the county and potentially state level. I walked out of that office feeling lighter than I had in months. What Karen had spent years building with intimidation and control was now under formal scrutiny. This wasn't some internet argument or neighborhood squabble. This was the real process of law working in my favor, and she had no idea what was coming. I didn't rush to inform her. There was no need. The legal notifications would be delivered through proper channels. She'd find out soon enough, not from me, but from the county itself. In the meantime, I quietly continued preparing for the court date regarding her lawsuit. My legal team filed a motion to dismiss the case entirely, based on lack of standing. They included all supporting documentation, along with an affidavit from the title company and a signed declaration from the county confirming the HOA's administrative status was under investigation. Karen's case was built on the premise that she, acting on behalf of the HOA, had legal authority to enforce its rules on my property. But that premise was crumbling fast. Without jurisdiction, and without a valid corporate standing, her entire case had no legs to stand on. But I didn't stop there. In addition to the court and county efforts, I filed a formal complaint with the state's Department of Consumer Affairs, which oversees HOA compliance and governance issues. My complaint detailed Karen's overreach, the HOA's lack of legal transparency, and the attempt to exert authority over a non-member homeowner. I attached all supporting evidence, requesting an investigation into the HOA's operations and demanding that the board be held accountable for its actions. This wasn't about personal revenge. It was about ensuring that no one else would be subjected to the same kind of harassment and manipulation I had endured. As the days passed, I could sense something shifting in the neighborhood. Karen was no longer walking around with the same air of certainty. The clipboard disappeared. The passive-aggressive notes stopped appearing. She even skipped a scheduled HOA board meeting, something she had never done before. Word had started to spread that something was happening, something serious, and although I hadn't told anyone the full details, neighbors were beginning to understand that her grip on the community was slipping. The fear that once kept people silent was fading, replaced by curiosity and quiet support. Some even approached me discreetly, asking if I needed help or if I could explain how they too might challenge some of the rules they'd been forced to follow for years. For the first time since moving in, I felt a sense of real empowerment. Not just for myself, but for the entire neighborhood. This wasn't just about winning a lawsuit. It was about exposing something bigger, something rooted in arrogance and illegitimacy. Karen had assumed no one would question her. She had counted on intimidation, on the complexity of the legal system, and on the apathy of neighbors. What she hadn't counted on was someone like me taking the time to learn the rules better than she did, and using those rules to expose the hollow shell she had built her authority on. It happened faster than I expected. Just days after filing the motion and submitting all supporting documentation, I received an official notice from the county. The HOA's corporate status had been formally reviewed and flagged as administratively inactive. The reason was clear: years of noncompliance, missing filings, lack of transparency, and numerous procedural violations. The association Karen had relied on for authority was no longer recognized by the state as a legally functioning entity. In practical terms, it meant the HOA couldn't sue, couldn't collect dues, and most importantly, couldn't enforce any of its rules. The power Karen had wielded for years was now nullified by nothing more than the law itself. As soon as that status was updated publicly, my attorney sent a supplemental filing to the court handling the lawsuit. The document included the county's notice of dissolution and a request for immediate dismissal of the case on the grounds that the plaintiff was no longer a legally recognized organization. We didn't even need to get into the specifics of my property being outside the HOA boundaries anymore. The entire foundation of Karen's case had crumbled beneath her feet. The court responded promptly, and within 3 minutes of that final motion being reviewed, the judge signed off on the dismissal. Just like that, it was over. What struck me most wasn't just the legal victory, it was the silence that followed. Karen, who had once been the loudest, most visible force in the neighborhood, suddenly disappeared from view. There were no more warning notes, no emails to residents, no HOA meetings. The signs at the neighborhood entrance referencing the HOA were quietly taken down. It was as if the entire institution evaporated overnight. Neighbors who once spoke to her in hushed tones now walked by without acknowledgement. The fear was gone, and in its place was a quiet sense of liberation. I hadn't set out to destroy the HOA. My goal from the beginning was just to protect my rights as a homeowner. But Karen had taken things too far, turning a voluntary community agreement into a tool of personal control. She tried to use bureaucracy as a weapon, assuming no one would take the time to push back or peel back the layers of false authority she had built. But once the truth came out, it couldn't be ignored. The county's decision was final. The law had spoken. Some residents reached out to me after everything unfolded. They expressed shock, relief, and, in some cases, regret for having stayed silent for so long. Several admitted they had always suspected something wasn't right with how the HOA was run, but were too intimidated to question it. Others shared stories of their own, being fined for minor violations, being shamed publicly in meetings, or feeling as if they couldn't enjoy their homes without Karen's constant surveillance. I listened to all of it not with judgment but with understanding. I had been on the receiving end of the same pressure, and I knew how suffocating it could feel. There was no celebration, no parade, no dramatic confrontation, just an overwhelming sense of peace. My driveway, once a target of complaints, now sat untouched. My yard, which had once been photographed and criticized, grew as I pleased. No one cared. No one objected. Life returned to normal, or rather, to the version of normal I had originally envisioned when I bought the house. Quiet, respectful, and free. Though Karen had vanished from community life, her story became something of a legend. People referenced it in casual conversation, often with a knowing glance or a shake of the head. She had gone too far and lost everything. Not just her position, but her credibility. Her fall wasn't loud, but it was complete. The power she thought she could hold indefinitely had proven to be temporary, dependent on legality, compliance, and the community's trust, all of which she had squandered in her pursuit of control. As for me, I didn't pursue revenge. I didn't seek damages or file a countersuit, even though I likely had grounds. The dissolution of the HOA and the dismissal of the case were enough. I had defended my rights, restored peace to my home, and helped reveal the truth behind an organization that had overstepped its bounds. And perhaps most importantly, I had reminded others that authority is only as strong as the foundation it rests on. When that foundation is weak or misused, it will collapse under the weight of its own arrogance. 15.